Hello and welcome to Texas Justice Review. Today we're going to talk about the judge in Texas that has been arrested and is facing trial. This is one of those cases that I like because I hate to see people. There's a lot of judges that I know that put themselves above the law. And here's one that Baxter County District Attorney's Office was not playing around with. Shout out to them for being brave enough to take on a judge who has abused her power. This is the case of, I would say, ego over judicial conduct, ego over the rules of civil procedures, and ego over the rule of law. There are a lot of judges that have egos. You upset them, they take it out on you. And this is one of those cases. Now, I usually like to do my videos at 10 minutes. But now this may take over about 30, 35 minutes because I have to read a lot of things that's happening. I'm going to outline how this got started. I have a copy of the transcript that's what happened in the courtroom, and I have a copy of the indictment. What I don't have is a copy of the state admonishing her for what she did. But there's two other things that she did that, the state did admonish her for. And I should just say it right now. She had an LGBT flag in a courtroom. She was admonished for that, and it was overturned, I think. And then she was admonished for using her position to congratulate, a Facebook post to congratulate about 12 lawyers, on their victories in the courtroom. And that finding violated the state of Texas canon rule law. So she's got a history of, bias and prejudice, I guess. I don't want to judge her. There's a relevance, the canon rule B2B, the Texas Code of Judicial Conduct proves its relevant part. A judge shall not lend the prestige of judicial office to advance the private interest of judges or others. And she violated that, and they admonished her by giving a public reprimand. So this was in 2000-something. Let's see, when did they do this? February 6, 2020. So that was about 6 years ago. She did that, and she was congratulating these lawyers on their wins in the courtroom, and she was ordered to complete an additional 4 hours of instructional recited above what they said above within 60 days from the date of the written notification of the assignment of a mentor to control her. So evidently she's out of control, so they had to admonish her, and she has to go through all these training and stuff. Okay, so let's move on. So let's go to the transcript. Here's what happened in court. This gentleman was given, instead of going to jail for a year, Mr. Collins, he was given community service. And apparently no one knows if he did or did not commit the community service, but the prosecutor came back and filed a violation that he did not complete the community service he said he was going to do, and therefore waives his chance of freedom, so he has to go back to jail for the 1 year. That's the basis of this whole argument. So in the court, I'm going to go through the transcript because this is going to set up how she got arrested. So the defendant, Ms. Russell, let me see, we'll go back 2 things. The court, does that cure? Okay, so there was an argument that happened where the prosecutor sent in an amendment to their motion before the judge, and she objected to that motion, and then the judge questioned the prosecutor, and the prosecutor said, okay, fine, we're not going to go ahead with the amended motion. We're going to go ahead with the original motion that we filed and served on time. So the judge is asking, are you ready to proceed on that groundwork? She said yes. The defendant, yes, ma'am. This is Mr. Collins. So apparently Mr. Collins is speaking. And if you have an attorney, you shouldn't be speaking. The attorney has to speak for you. But for some reason, the judge is talking to the defendant which is wrong. You have to speak to the attorney, not the defendant. And that was the first thing that should never have happened in the courtroom. So the court, okay, so Mr. Collins, we'll start with you, with setting the groundworks for you, okay? The judge is talking to the defendant while there's an attorney standing there. The judge should have said to the attorney, is your client ready? You have a plea for your client. Now, all of this is not legal advice. It's just things that I know 20 years, 2 decades of covering judicial news. So here's the court. This is the judge. Back on the 14th day of July, on 2023, you submitted a request, an application to be placed on a community supervision as opposed to serving any time at the Baxter County Jail for the offense that you were charged with. I will read it later. He was charged with domestic violence or some kind of assault. That was assault, bodily injury, offense to a family or household member alleged to have taken place on the 28th day of December 2022. So we'll skip all of that. We'll get down to, if the court determines that you indeed violated the court order and condition of probation, that you could face the full range of punishment for the offense you were placed on probation for. And then the defendant goes, yes, ma'am. I don't know why the defendant is answering. The lawyer should be talking for the defendant. The range of punishment can be up to 1 year of jail time in the Baxter County Jail. In addition to 365 days of jail time, the court could fine you up to no more than $4,000. You could also lose your Second Amendment constitutional rights to bear firearms, have a gun, and handle ammunition. Mr. Collins, the state filed a motion to revoke your probation. And that's the premise of this hearing today. We are on that hearing today that you were warned about. So my question to you, Mr. Collins, do you understand why you are here today? He said, yes, ma'am. Still, why is she talking to the defendant when he has an attorney? The court, my last question to you is, do you understand the possible outcome of today's hearing? Yes, ma'am. The court, okay, with that, we will proceed. Mr. Collins, please raise your right hand. He's sworn in. The court, you may put your hand down. Miss Marcia, who is a prosecutor, as a prosecutor for Baxter County and the attorney for the state of Texas, why are you here today? And then she said, we are here today because the defendant, Mr. Brian Keith Collins, was placed on probation by the court on the 14th day of July 2023 for a period of 12 months and extended for a total of 1 year under the provisions of the adult probation and parole law as reflected by the filings in this court. Subsequently, the defendant violated Condition 4. The Baxter County, Texas, in Baxter County, Texas, the defendant, Brian Keith Collins, did then and they failed to report to supervision officer as directed for the month of October 2024 in violation of the conditions of number 4. I guess he had a bunch of conditions. Additionally, defendant violated Condition 15 on about the 1st of November 2024, Baxter County, Texas. The defendant, Brian Keith Collins, didn't then fail to complete 40 hours of community service restoration in violation of Condition 15. So she's going after Condition 4 and Condition 15. I guess there's others. And let's move on to the juice. Okay. So Miss Russell, who was the one that brought the charges to arrest this judge. Judge, can I get 2 seconds to remind him of our conversation about this portion? So, apparently, the attorney had a conversation with her client, Mr. Collins, about what to answer to. So, which means the judge goes, Mr. Collins, I'm going to ask you whether the allegations by the state are true or not. True. So that's all you need to respond to right now. So the judge is setting him up to send him back to jail. If you're smart, you'll see that already. Your attorney will take care of vetting out and explaining an explanation you may have by calling other witnesses that may controvert, refute, and disprove the state's burden to prove that you violated what you violated. No, it said that you violated. Ms. Russell, the attorney for Collins, is saying, Judge, can I just get 2 seconds to remind him of our conversation about this portion? The court says yes. And they had a conversation. Ms. Russell, okay, Judge, this is the court now. This is the judge, Gonzalez. So my first question to you, Mr. Collins, is it true or not that this is the juice that you failed to report to your supervising officer as directed and ordered by the court for the month of September and October for the year 2024? Is that true? In violation of condition 4. Now she's going by condition, like from condition to condition. Is that true or not, Mr. Collins? Yes, ma'am, it's true. So he belted out, it's true. He violated it, right? And the court, we have it true. So Miss Russell, who just told him maybe not to say true, the guy says true. And she immediately jumped in, his attorney, Judge, I'm going to just, and she goes, and the judge jumped in, the court goes, plea from, and she says, no, a moment, Your Honor. Mrs. Russell conversed with her client. So apparently he gave the wrong answer. He didn't understand what she was saying, true or not true. So he goes true. And he was supposed to say not true. And she immediately jumped in and corrected him as his attorney. And the defendant, oh, okay. Mrs. Russell, his attorney. So Judge, Mr. Collins would like to recall his plea for not of true and correct the record. So this is what transpired. She conversed with her client, Mr. Collins, and apparently told him to say, if she asked about true, say not true, say, and I didn't think he understood what the attorney was telling him. So when the judge asked him, he says true. And then she immediately jumped in and says, Your Honor, and I want to converse with for a moment, Ms. Russell, a moment, Your Honor. And the defendant, oh, okay. So she must have said something to him. You said the wrong answer. Now, I'm going to give you a case law in a second to explain what just happened. So Judge, Mr. Russell, so Judge, Mr. Collins would like to recall his plea for now of true and correct the record. Here's the law. If you make a plea before a judge, and I'll read the law into the record in a second, into this thing in a second, and the judge did not make a judgment on the plea, you can withdraw the plea. Actually, I'm just going to read this out. So here's it. Absolute right to withdraw a guilty plea before sentencing. This rule is not just practice, it's settled law. In Jackson versus the state, 590 SW.2D 514, Texas Criminal Appeal 1979. And this is a criminal case. It's not a civil case. So this applies. A defendant has an absolute right to withdraw a guilty plea at any time before judgment is pronounced. Even if the plea was already entered in front of the judge, even if the judge accepted it, before sentencing, the defendant can change it to not guilty. So that is the case law. After sentencing, it's too late. You have to do an appeal, you have to go through it. Texas Criminal Code of Procedure, Article 27.4. This article governs plea. It recognizes that a defendant may plead guilty or not guilty. A guilty plea must be freely and voluntarily made. And it's not Texas Code 26.13. Texas Code of Criminal Procedure Act 26.13a requires the judge to warn the defendant before accepting a guilty plea. So she's also under law, the judge, you must warn the defendant under this criminal act. Now, I don't think this attorney knows about these acts. I mean, she doesn't have the time to research. This is why you get caught in a moment and you don't know the law, so you have to research it. The judge usually ask the defendant, are you sure you want to enter a guilty plea? Do you understand the circumstances of accepting a guilty plea? Have you spoken with the prosecutor about accepting a guilty plea? And that language goes on with the judge. You understand what you're doing. Clearly, immediately when he said yes, the attorney jumped in and realized this was not the direction that the attorney gave him. And that's going to be very important in the next section that we're going up to. So here's what happened. And this is what I'm going to do with that response to court. Attorneys are not allowed to coach answers to their clients. Okay. He was under oath. He stated true. That's what the court's going to recognize. So this judge is not following criminal law, that you have to tell somebody if they enter a guilty plea, the consequences of it. And a person has a right to change that guilty plea to not guilty as long as the judge doesn't issue the sentencing yet. So this is two laws that is already against this judge. But she has an ego. She's got an ego with this lawyer. She's trying to prove something. That's just my comment, personal comment. So let's get back to this. Attorneys are not allowed to coach their clients. The attorney can immediately correct their clients if they said something that was not discussed and a different answer was given. The attorney has a right to correct the client, especially if they had a discussion about what to answer. He was under oath. He stated true. That is what the court's going to recognize. So she's overriding the lawyer. She's overriding the law. You can make a record of that. He was told by his attorney to take that answer back and stated not true. He stated not true. My next question to you, Mr. Conling, is this. Is it true or not true that you violated condition 15? So now that the defendant, Collins, clearly understands what his attorney is trying to get him to do, this is how he answered question 15. My next question, Mr. Collins, is is it true or not true that you violated condition 15 by failing to complete 40 hours of community service in restitution by the first day of November 2024 as ordered by the court? And he said, not true. So which means he didn't understand what was going on in the first question. And now that he understood what his lawyer was trying to tell him to answer, he's now answering it correctly. And then the court, not true? Yeah, that was Ms. Gonzalez, Judge Gonzalez. Okay, so state, this is what the prosecutor, you have a true plea for violation of condition 4, and that Mr. Collins then withdrew and stated not true after being coached by his attorney. If the language is every time an attorney speaks to their client and you're trying to say, oh, they're coaching the client, attorney has a right to reference their client and represent them and instruct them on how to give the answer. This is not coaching. This is representing your client and knowing the law and trying to get your client the best favorable outcome in the courtroom. So that she's saying she's coaching her client is a different language. Okay, I'm going to, and then Mrs. Russell, Judge, I am going to object to that. This is, and then the judge goes, it's on the record. You can object all you want, Ms. Russell, and now she does the attitude start. This is the ego. This is the attitude. And let's see, Ms. Russell, I understand your position. The court, stop. It's not, it's on the record. Your argument. Stop that. The court is saying stop. It's on the record. Your argumentative ways are not going to work today. Stop, 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 or I'll hold you in contempt, Ms. Russell. I will hold you in contempt. So you see the attitude? See what she's starting? This is not law. This is not the rule of court. This is beyond judicial conduct. A judge has a right. I was going to get to judicial conduct. They have perform their duty in a professional manner in public's interest, in the interest of the public. And so this judge is now antagonizing this lawyer. She's going after her. And then Mrs. Russell, Your Honor, I'm allowed to speak. The court, you're allowed to speak, but you're not allowed to be argumentative or argue just for the sake of arguing. Now, this wasn't just for the sake of arguing. What's happening right here is that the judge cut her off. You have no rights anymore in this courtroom. Basically, I caught your client saying true, and I'm going to hold on to him saying true. And these laws, the Code of Criminal Procedures that protects defendants, and the Code of Procedures and the case laws that protects Mr. Collins does not apply in her courtroom. So she's being a bully at this point. And I'm arguing for the sake of arguing. The court, you are, Ms. Russell, this is the attorney. I'm not arguing for the sake of arguing, but she cut him off and said, you are. The court, you either will hold your tongue and act professionally, or I'm going to hold you in contempt. And this is where it went south for this judge. Mrs. Russell, Your Honor, the court, mark your record. Mrs. Russell, I am acting professionally. The court, you are not. Mrs. Russell, this is why the court, you are not. I get to raise my voice in this court. So she's, now it's a confrontation. Now it's a hostile environment between the judge. The judge is making between the lawyer, the client, and herself. Mrs. Russell, I'm asking the court, not you. Then she cut in, she says, I'm asking for a recusal. So now she's asking the judge to recuse herself. And this pissed her off. And this is where the law gets broken by this judge. Oh, in my own case, I asked for a judge to be recused, and he did the same thing to me, even worse than what she's done. And I don't know why he's in jail, not in jail. Oh, we'll get into that in a second with the DAs and how the DAs handle these judges. And then the judge, as soon as she asked for a recusal, the court goes, take her into custody and put her in the box. We are not having this hearing this way. So they arrested the lawyer, put her in handcuffs, and put her in the jury box. And I'm requesting a recusal. Please contact Judge Hawley's office. I don't know if that's the chief judge. Mrs. Russell, you need to contact him now, she's telling the judge. The judge, put her in the box. Judge, I'm entitled to a hearing on this. So when you ask for a recusal, the judge has to stop everything immediately. Once you say recusal, it's like when you're talking to a cop, and they said, do you have a right to remain silent? Anything you have against you? Okay? And the cop goes, do you understand what I just said? And he says, yeah, I want a lawyer. Any question after I want a lawyer is dismissed. Any conversation. And the same thing is happening here. Whenever you make an oral or a written request for a recusal from a judge, everything stops. It's supposed to stop. But your client isn't, I'm entitled to a hearing on this, which is the recusal. So now the case is supposed to be stopped and stalled. You can't proceed with the case anymore because she asked for a recusal. The judge is going to have to say, okay, at this moment, there's been a recusal or there's been an appeal or whatever is filed, oral or not, I got to stop the case, file your recusal, and then have the chief judge deal with it. But the judge goes along, to Judge Gonzalez goes along to say, your client is entitled to a hearing today. She's continuing after the recusal request. Do you want another attorney to step in or not? I think she's probably talking to Mr. Collins, because otherwise he's going to sit at the Baxter County Jail until this is resolved with you, meaning the recusal. Mr. Russell, Your Honor, Mrs. Russell, the attorney, I'm entitled to any hearing on any criminal contempt. So she holds in the criminal contempt, have to get a hearing. You can't just hold me in contempt without a hearing. This is the lawyer speaking. The court, are you going to, and she goes, for now, for show cause. It's choppy. I can hold you in contempt, Mrs. Russell. If you got that wrong, you are going to behave professionally, or aren't you? Mrs. Russell, Your Honor, I will, but in between it says the court. That's a real simple answer. Yes or no? Yes or no? I have a full control of everything that goes on in this courtroom. I've been given that duty by the voters of Baxter County. Okay. So, Mrs. Russell, I ask you one last time, are you going to conduct yourself professionally or not? Mrs. Russell, I will. The court, okay, then take off the handcuffs, put her back at the table. I will hold my ruling in abeyance. Mrs. Russell, I am requesting a motion for recusal, Your Honor. You have put me in handcuffs while sitting with my clients. I'm requesting a recusal. Mrs. Russell is taking out her handcuffs. The judge, you can sit back at the table and continue to argue, or we can reset this matter into next year. This is 2026. So just to punish her, she wants to set it to next year. Wait, so this is 2026. Let's mark this. Okay, we'll come back and see what year this is. This is probably 2025. You can sit back at the table and continue to argue. You can reset this matter into next year, and Mr. Collins will sit in there, I guess in jail, until we get all of this resolved at your request. Mrs. Russell, I'm requesting a recusal. This is the third time she's asking for a recusal, Judge, on the and the court. Take him back and take him into the back. So now the case is done. This guy's going to sit in jail. Mrs. Russell, records today. The court, he can be sent back to the Baxter County Jail. You can file your motion and you can file your recusal, and we'll take care of it in a timely manner. Addressing a client, they're going to take you back now. The court, you will not run around these courtrooms. See, this is the ego. This is the ego. You will not run around these courtrooms, especially 13, which is the judge's courtroom, and think you can just conduct yourself in a way you've been conducting yourself for at least the last 6 months, Mrs. Russell. Your Honor, I've only been licensed for 5 years. The court, well, then it's 5. Mrs. Russell, and I have not conducted myself unprofessionally whatsoever. The court, evidently you are in an echo chamber and your thoughts and your own thoughts, because if you take a survey among the judges and other co-counsel and other attorneys in this county, you will find differently. Your Honor, the court, I will sign the recusal and you can go. Mrs. Russell, on the record, these are the reasons why I'm entitled to a recusal. The court, you are, Mrs. Russell, based on the bias and prejudice of this court. The court, you know what, Ms. Russell? You will get your recusal and you will never practice in this courtroom again. I'm going to exclude you from being able to practice in this courtroom. Mrs. Russell, and I, the court, you may leave now. Send that order for recusal and I will sign it immediately. Ms. Russell, sounds good, Judge. And find yourself grateful that I'm not filing a grievance against you. Mrs. Russell, you can leave. Mrs. Russell, walking out of the courtroom, Mrs. Russell, and you as well, Your Honor, for the ex parte communication with the probation officer and the attorney for the probation office, which those are great accusations, ma'am, she's telling her. So apparently there was communications between the judge and the probation officer directly without this attorney. That's illegal. You can't do that. You can only speak to the attorneys. So that's what she's confronting her about. I think it ends right here. Yep. So that is what happened inside the courtroom. That transpired. And that is what got this judge arrested. So let's take a look at the indictment. While we're pulling this up, I just want to say judges are not supposed to get into it with anyone. They're supposed, you know what, let's pull up the canon rule of judicial conduct. Let's see if we can get that out. And it's just the first one. Let's see, Texas. Okay. So let's read a little of the Texas canon rule of canon rule, uphold the integrity and the independence of the judiciary. This is number 1. Canon rule number 1, you have to uphold the integrity and independence of the judiciary. An independent and honorable judiciary is indispensable to justice in our society. A judge shall participate shall participate in establishing, maintaining, and enforcing high standards of conduct, and should personally observe those standards so that the integrity and independence of the judiciary is preserved. The provisions of this code are not to be construed and applied to further the objective. Here's number 2. A judge shall comply with the law and should act at all times in a manner that promotes public confidence in the integrity and impartiality of the judiciary. A judge shall not allow any relationship to influence conduct, judicial conduct or judgment. A judge shall not lend the prestige of the judiciary office to advance the private interests of the judges or others. Remember, we read that when she was helping the attorneys, the 12 attorneys. Let's see. There's one. Let's see. Just the main headline. The Code of Conduct is not intended as an exhaustive. Our legal system is based on the practice that an independent, fair, and competent judiciary will interpret and apply the laws that governs us. The role of judiciary is central to American concept of justice and the rule of law. Intrinsic to all sections of the Code of Judicial Conduct are the precept that judges, individuals, collectively must respect and honor the judicial office as a public trust and strive to enhance and maintain confidence in our legal system. A judge is an arbiter of fact, of law, for the resolution of disputes, and a highly visible symbol of government under the rules of law. This is the Judicial Code of Conduct. There's a whole bunch of them that the judges fall under, but I'm not going to get into all of that. Oh, here's one. This is one is interesting. A judge shall not, in the performance of judicial duty, by words or conduct, manifest bias or prejudice, including but not limited to bias and prejudice based upon race, sex, national origin, age, sex, or that kind of socioeconomic status, and shall not knowingly permit staff and others to do the same. And so number 5 is a judge shall perform the duties without any bias or prejudice. So I think that's what this attorney filed. Okay, so here is the indictment of defendant Speedlin Gonzalez Rosie, and this is by the Baxter County Prosecutor's Office. Baxter County District Office files this. It's by the state of Texas. Okay, so here's what it reads. In the name and by the authority of the state of Texas and the grand jury of Baxter County, so this went to a grand jury, the state of Texas duly organized and sworn by such at the January term AD 2026 of the 144 Judicial District Court of said county, and the said court and said terms. I'm not going to read all that nonsense. Count number 1, unlawful restraint, peace officer and judge. On or about, this was 2024, on about the 17th day of December 2024, in the Baxter County, Texas, Judge Rosie Speedlin Gonzalez, hereby styled defendant, while a public servant acting under the color of her office or employment, did then and there intentionally and knowingly restrain Elizabeth Russell, the complainant, by restricting the complainant's movement without her consent, so as to interfere substantially with her this wasn't printed right, in violation of Texas Penal Code 20.02. What penal code did we read from? We read from 27. Count number 2 is official oppression. The first one was restraint. On about the same day, Baxter County, Texas, Rosie Speedlin Gonzalez did not Judge, Rosie Speedlin Gonzalez, while a public servant acting in the color of law of employment, didn't then intentionally subject Elizabeth Russell to arrest and detention that the defendant knew was unlawful, and the defendant was acting under the color of the office as a public servant, namely County Court at Large, Judge of the Baxter County Court at Law number 13. That's the indictment. Indictment's not detailed. I guess, they just made it what it is. So that's what now what's going on right now is that she was suspended without pay. And that's bad. If the Judicial Board of Conduct, I think, did their analysis and they reprimanded her. I didn't get a copy of that yet. So what's happening is that they're going to suspend her, and I think she's going to serve some jail time because it's moving fast. So let's talk about how a judge gets arrested. You go to the district attorney's office in that state, and the district attorney's office in that county takes the complaint about the judge, and they take it to a grand jury. And when the grand jury hears all the arguments, and I'm sure that they heard from Ms. Russell, and they probably read the transcripts that I read to you, and they said this was not supposed to happen. They put in the applicable law that they're supposed to put in, and the grand jury comes back and says, yeah, she did break the law. She shouldn't have done what she did. This doesn't mean to say she's guilty. All it means is one set of jury said there is sufficient evidence that she can be prosecuted. That's all this is. There's sufficient evidence here that she can be prosecuted. This goes to a real jury that's going to take it, and then her attorney has to come up and fight and use all the tactics that they use and all the case laws that they trump this and trump that, and all the discrediting Miss Russell and discrediting Mr. Collins and saying, oh, he already said yes, and she annoyed her so much. But a judge is not supposed to get annoyed, as you can see from the canon rule. And so that argument is going to take place before the trial, at the trial. And this is going to go to trial, unless she pleaded out. But she's going to do some jail time. But in Dallas County, here's what happens why a judge almost never gets arrested. You look at Dallas County, the district attorney's office is Democrat. All the judges, except for a few, are Democrats. So if you were to take a Democratic judge to a Democratic DA, chances are they're going to find some reason to say, well, we don't have enough for indictment. We're not going to take it. We know the person, which is what happened to me personally. Judge Michael Snipes, he broke the law, official misconduct, oppression, suppression of evidence, all this kind of stuff he was doing. And I took that to the district attorney's office in Dallas County, and they said, because he's a friend of the district attorney, we can't prosecute him. And I even put on there, if you can't prosecute him, could you send it to another county? And they did it. So district attorney's office normally protects their judges, because just remember, when someone is charged by the district attorney's office, it's usually a criminal charge. And they have to send these cases before people like Ms. Gonzalez. So there's a relationship between the district attorney's office and the judges. District attorney arrests somebody and they send them before the judge. The district attorney has to go before the same judge and argue that case. So this prosecutor probably came from the district attorney's office, and because she has to prosecute the person the district attorney charged, which is Mr. Collins. But I don't know, is the local prosecutor, how it works in Baxter County, but most prosecution is done by the district attorney's office. So there is politics here. Or something is going on here that where Ms. Gonzalez is probably not in the same political party, or maybe she's not in good terms with the district attorney's office. Maybe she's just kind of one of those judges they really don't like, and they feel, but if they liked her, if she was part of their political party, the wrong that she did, and she did wrong, she violated this guy's rights, and was bullying this lawyer, falsely arrested this lawyer, and hold her against her own will for no particular reason. that she just wanted to show her ego over this judge. And this is my courtroom. I get to yell. You don't get to yell. I'm the boss here. But I have a feeling if she was a friend of the political party of Baxter County, they would never arrested her. They would have said, well, it was an unfortunate incident. But this is a neutral situation where there's no connection there. So they felt, well, we can arrest her, but we still got to take her before a grand jury and have her see what they say about it. And they took her to a grand jury, and this is what happens. And that's why she's arrested. And I mean, I'll tell you something, covering the news for 2 decades with these judges. I've seen judges done worse than Gonzalez. And they're still sitting there in Dallas County. They've done worse. I know 4 judges that have done worse that should be arrested, but they are part of the political party of the DA's political party. And when I go to some of the events, I see the same judges who committed these crimes there. And if I were to contact the Department of Justice and say, hey, can we set up a sting and I can file these charges that are real legitimate charges and watch what the DA does? This is the reason why Ken Paxton wanted to take over the DA's office or the DA's office in Texas and monitor them. This stuff happens. So I think Gonzalez is one of about 15 judges that breaks the law, especially in family court. They break the law. They let people get away with perjury and they go after you, especially the men. And you cannot get the DA to arrest these judges. I know Michael Snipes, when he was at the district attorney's office. Now he's a Florida judge, assignment. Another person found a judge manipulated records, lying, deceiving, and that woman took that evidence, strong evidence that the judge lied, and that judge was Melissa Bellin. Melissa Bellin, she said, and she took it to Michael Snipes when he was in the district attorney's office in Dallas County, and he will not prosecute her for tampering with documents that cost this lady about $80,000. So a lot of things are happening. Which this woman is just one of many, and she just happened to be on the wrong side of the track, and she got caught red-handed. The rest of the judges, no matter what you say to the prosecutor's office, the DA's office, they're all friends. It's one big happy family until it's not. And that's where you go to jail. This is Serrano Keith Baldio. Nothing here is to be taken as legal advice. And I think more judges needs to be complained about through the right channels. And I guarantee you there'll be more arrests of these judges for putting their ego over the rule of court, over the canon rule, the professionalism, and over the law. Just because you upset them, this is what they do. Judges don't like you pissing them off. And if you piss them off, your case is out the window. Me, I didn't care when I went after the family court corrupt criminal Judge Michael Snipes. I didn't think I have to beg for justice. I didn't think I have to plead for justice. I should have just gotten it. But let's see what happens to him. I'm gonna report this case because he did worse and see what happens, and I'm gonna do a follow-up on that. This is Serrano Keith Baldio. Apologize for taking so long, but there's a lot of information we had to read. Don't forget to subscribe because you'll know about new videos. Like and share so other people can know what's going on. Thanks for watching, and bye for now.